I am pleased to be moderating a panel on litigation and government strategy. And I am pleased to announce my panelists, or my joint presenters here. Our newest employee, Vivian, just started on Tuesday, so this is a big first week for her, and David, and I'll let them introduce themselves a little bit. But we're going to talk about litigation, kind of what's changed in the last 10 years, what we're seeing today, and also just kind of things to keep in mind for companies going forward. All right, and I'll just briefly, my name is Amanda Johnston. I'm a partner at Gardner Law. I've been with the firm, I think I was actually the second lawyer after Mark, so I've been here about 7 years. So I've seen a lot of growth. It's really exciting to see such a big, amazing team that we have now. So I will pass it on to Vivian and let her introduce herself.
Hello, everyone. My name is Vivian Egbu, and I'm an attorney here at Gardner Law. And so I've been practicing for about 14 and a half years. I started my career off in civil litigation, so did that for about 10 years. And then I moved into government work. I started at Health and Human Services Commission in Texas in the Healthcare Enforcement Division. And then after working there for a couple of years, I then moved to work as the Assistant Attorney General for Texas. And that was my position prior to joining Gardner. And in that position, I prosecuted, oh, can you guys hear me?
Turn it on.
It is on. Okay, sorry about that. So, can you guys hear me okay? Or should we wait? Okay. So as an assistant attorney general, I prosecuted healthcare fraud cases, and most of those cases were illegal kickbacks and false claim, false promotion. And I also got certified in healthcare compliance. So that's a little bit about me. Great.
And now that you're with us, it'll be alleged false claims.
Yes, exactly. Alleged illegal kickback.
Right. I'm David Graham. I started my career litigating, did for 25 years or more, for medical device and drug companies, product liability cases. And in the late 90s, I started doing cases for drug companies, but they happened to be related to animal feed and food related things. And so I got interested in doing food law. And I've done that along with other medical device and drug cases. So I work on those kind of cases, but also increasingly working in opposition with, hopefully sometimes with, state agencies and the FDA and USDA in disputes about whatever our clients are challenged with.
Great, thank you. And we're going to start out, David's going to do, oh, sorry, I didn't go over the agenda yet. We're going to talk about how the government shows up, things that you should be thinking about, how that's changed, what drives escalation in investigations and litigation, how cases actually unfold, and then we'll do a little bit of a panel discussion. So I will hand it over to David to do a brief primer on enforcement.
I was going to stand up, but I think I'll stay here because I just block everybody then. So I hate to be rudimentary for those who've been in this business a long time, but I often have clients that don't understand that FDA enforcement or USDA enforcement is law enforcement. So it's not just because you interact with them often doesn't mean that they're not just like an officer of the law that tells you not to speed or to do something different. If they tell you to do something different, you better have a good reason not to do that, right? And that understanding sometimes can help avoid problems. The law enforcement incentives don't change, right? It's protecting consumers and patients particularly from physical harm, consumers from fraud or misleading advertising or things like that. That doesn't change no matter who's running the regulatory bodies in question, and fraud. So protecting the government purse, whether it be the state or the federal government, is always fashionable. Again, it doesn't matter which party's involved. So that's the perspective of the agency, and that's their job. And keeping those things in mind sometimes is helpful to not being faced with an escalation in enforcement. So, and now what we're seeing that I don't think I've seen as much of in 30 some years is more state involvement in food additives and having laws specifically related to that, and laws specifically related to the regulation of advertising around medicine and medical devices, where that was completely the province, or the states were happy to leave it to the federal government to do in that context. So that's kind of my preface. So state and feds work together a lot. Sometimes it's good. In Minnesota, usually it's good for me. We have a great Department of Agriculture and Health Department here, and when they're involved, they're responsive usually, and it's a good thing. I don't know about every other state in the union, but some aren't as good as ours, I don't think. Some of the tools that they use are one we left off there, and that's my fault, is recall. So in all matters we deal with, you're always trying to prevent market withdrawal or recalls or things like that. So that's always a tool that's a civil remedy that they don't need permission to engage or force in terms of going to court. Otherwise, it's inspections and interviews with people, market surveillance if there's a particular kind of product that's causing a problem, a particular kind of promotion that's causing a problem. We're going to learn more about what the government is looking for in a minute from Vivian. But those are the general tools. So they don't change much over time. I mean, they can detain products. They can prevent shipment to the extent it's in interstate commerce. So they can interrupt your business to the, I do, this room, probably not the audience, but the USDA, for example, if they don't show up, you're out of business. You have to have a stamp, right? So it's from that extreme to finding out in an inspection that your label's wrong, or in a different context that might stop you from shipping product or things like that. So those are the general tools. Am I leaving any out that you can think of?
No, I think you covered most of them.
Okay.
Yeah, criminal, civil, consent decrees, fines.
Right.
Yeah,
Right.
and we'll talk a little bit more about kind of
Right.
how we see that.
Right. And so the next part is what makes things worse, right? You have a problem with FDA and maybe it rises out of an inspection and an FDA 483, and you can't resolve the issues in the closing meeting, and you don't do the right things to resolve it. Let's put it that way. Nate doesn't help you. No, it's all right. So there's always a problem with not doing what they ask you to do or not negotiating properly with them what you have to do. So just blowing off the FDA is always a recipe for escalation. If there's risk, obviously physical risk to patients is number one. If it's a medical, well, and food too, right? I mean, if there's a food outbreak or there's evidence from adverse event reports that people are being harmed, that'll drive escalation fast. Now, the escalation might just be a recall, and that takes care of it. So in any event, that's failure to act in good faith is the worst, because it's not only maybe illegal if you lie to the government, that's a crime in itself, but if showing disrespect for the people who are trying to resolve the problem with you will always make it worse. Unfortunately, I show up after that disrespect has been shown already, unfortunately, and you have to repair that, because what do you lose then? You lose trust. And without trust, it's hard to get back going, even if you resolve everything. So in any way, and then fraud, of course, if there's an indication that there's ill-gotten gains, it's a problem. So what triggers them? Well, it could be recalls, it could be FDA investigations of another company or a particular product. It could be an inspection where something's discovered, a complaint from consumers, a complaint from competitors, and whistleblowers, of course, are always people that can get investigations going. And whistleblowers come about because you didn't pay attention to them when they complained in the first place. Or even worse, you treated them poorly or fired them What are the tools? We talked about some of them, but investigation tools include asking for documents, asking for interviews. One we don't have up there is search warrants. So if they can get a judge to sign a warrant, they can use that to find out about very specific things that they're investigating. And then the paths to resolution are, hopefully you just respond to the inspectors or investigators as it goes on, and you can work it out with them. And maybe even avoid an agreement or a consent decree. You can just resolve the matters. Usually it ends up in some kind of letter agreement with the state or a consent decree with the federal government. And hopefully you don't go to trial on some kind of civil matter, like a False Claims Act case or something like that. And then the other way is criminal prosecution. And you don't ever want to get there because that it happens. And again, that's usually because you ignored evidence that something bad was happening in your company. Not only ignored it, covered it up. So that's sort of the introduction.
That was great. Just to kind of level set what we're talking about here. And now I get to ask questions of you guys. So first, Vivian, welcome to Gardner Law. We're very happy to have you. You've been litigating in the government for the last 10 years. How have government investigations changed over the last 10 years from your perspective?
Okay, I can say, and I haven't been in government for 10 years,
Yes,
but for about 5 years. I would say within recent years, the government has become a little bit more aggressive in intervening in cases. And when I say that, I mean, anytime there's an action against a healthcare company, the government does monitor, but they also have an option to actually intervene and be a party of the case. And so that has increased exponentially lately. Can you guys hear me? Yeah. And what that means, that has a very important meaning to the companies, because once a government intervenes in a case, there no longer is a statute of limitation. So whatever the allegations, whatever the amount that could be, the government can go as far back as they can prove, rather than just, the 5 years or 10 years that would have held the limit on the claim. So that could be a significant impact on a company if they are successful on the claim. So that's one really big thing. Another big thing that has changed through the years are what type of cases the government will pursue, because the government hears about a lot of cases, but they don't always have the manpower to actually pursue the cases. And it used to be based purely on how much the damages were or how much the alleged fraud was. But in recent time, governments are also looking at patient harm. So even if the amount is small, if many patients were harmed or it's a concern of public safety, they will pursue the case. So those are a couple of big changes I've noticed through the years.
David, do you have anything to add on that?
Yeah, I would add two things. One is I think there's more state and federal cooperation and enforcement that's driven by resources. If the federal government doesn't have a lot of people to investigate, much less, well, first of all, inspect, but then investigate if there is some specific issue involved, then they can use their state partners, and they seem to want to be more willing to do that and not just keep it in their own arena. And then I think a little more willingness to force recalls and use administrative detention and exercise their muscle to stop commerce. I'm not saying they're wrong every time. It just seems like we weren't always there so fast. I had a matter that it actually had been going on a while, but the actual quote evidence that the FDA inspectors had, which they thought would justify a recall, they gathered 3 days before they said, we need a press release for a recall, right? Usually you got a little time to work it out. What was the problem? What was the result of the testing you did? How can we address this? And it was not, it was pretty quick trigger. So I think a little faster things like that.
Can I just add something that David said is true about resources? The government does have limited funds, but another thing that has expanded their resources is whenever there's a whistleblower, which a lot of these cases start from whistleblowers, they are usually represented by a law firm. And so when they intervene, they also have the resources of that firm, which is usually pretty large. So that also expands what they can do and how far they can go with a case.
Yeah, that's a really good point. And I think there's a question online.
Yeah, there is. What is the consequence of not responding? I'll start over. Are we good, Charlie? Here we go. What is the consequence of not responding or acting on warning letters from FDA? Is there any data on fines or civil or criminal actions FDA took if companies didn't act on warning letters? And does FDA have power to ask for recall or discontinue product for non-compliance if there is no safety hazard to public?
So the risk of not responding to a warning letter. I mean, I wouldn't advise that.
It's high.
I mean, they do have
complete power to
yes,
shut down
they do. They do have
that product anyway.
authority
Maybe
to
not
stop.
your whole business,
Yeah.
but yeah.
Yeah.
And I can also say that that would increase the scrutiny on the company because now the government is even more interested in what's going on.
Yeah, if you don't even respond. Yeah. I mean, obviously we don't know the facts, but I think just common sense, anytime FDA is coming to you with something, especially a concern, it'd be very wise to respond. They're not going to go away. They're going to keep coming back and it'll escalate.
It will escalate.
Yep.
I think most of their enforcement tools are at their disposal in that kind of
Yeah,
thing.
yeah.
I've always assumed that. I mean, you can challenge, right, based on the evidence and maybe they were wrong in their warning letter, but
Right.
why would you wait?
Right. Yeah.
It's a fight that has to be had either way.
A warning letter is simply a warning. So if you ignore it,
Right.
then the government will
Yeah.
just pursue you.
Right. They're not going to go away.
But
Okay.
you can operate with open issues from
Right.
warning letters as long as you're working on them. I mean, I've never.
Right. Well, especially if it's not safety, you should be able to have conversations with FDA and try to explain why maybe you disagree with what was in the warning letter or the deficiencies. But yeah, I wouldn't recommend ignoring. Okay, so another question here, David, I'll have you start this one. When a company first learns of a government inquiry or investigation, what usually happens next, or first, I guess, and what are the biggest early mistakes that companies make?
I think the biggest mistake is not having a plan for this to happen. So if you're in a more mature company, you usually have at least the team that's involved in dealing with inspectors, right? So they'll be kind of familiar with working with the FDA and so be prepared in advance, right? Not training people is another mistake about how to deal with somebody who stops you on the street and asks you questions about the business you work in and telling them their rights. I mean, it's not a long conversation as you can tell them, right? Or you can say, no, you know what, I can have this conversation with you, but I want to do it with the presence of my manager at my company. Or, I mean, you can exercise that, right? So if people don't know that, they engage in the conversations and aren't, that's a very uncomfortable. I don't know if it's comfortable if you're a lawyer, but it's, so I would say that. And then communications within the company aren't controlled, not that you're suppressing information, but you're not allowing speculation to drive what your response is. So you're not constantly reacting to what employees might be saying and you're trying to get them educated. And also the C-suite, make sure they understand what's going on. There's not always perfect judgment there. And so that's how I'd initially answer the question.
Vivian, anything from your side, kind of seeing companies being under investigation, anything that would cause you to apply more scrutiny?
I would say more scrutiny comes from what we gather from the interviews and the documents. If there are any hesitation to produce documents, that will raise an eyebrow, or if, if we're ignored or there's no cooperation, that definitely will increase the scrutiny. So just going along through what we learn normally determines what we feel about a case.
Can I say one other thing?
Yeah.
And that is, when it's at the level that there's interviews or document requests, it's not, gee, I'll just reach out to the people I know at the FDA that do the inspections and see what's going on. They may have no idea, and it's just best to have some experienced counsel if you don't have it right in the firm, and then proceed as if it is an investigation, not just a routine inspection.
Yep. Okay. And we've been hearing a lot lately about cross-agency collaboration. The DOJ, CMS, FDA, we've seen a lot of different initiatives coming out talking about how they're working together and collaborating. What does that actually look like in practice? Vivian, you can start.
Yeah, sure. So in practice, we essentially, the agencies will have regular meetings together, and the purpose of those meetings is just to see what's on the radar, what's going on in healthcare and companies, and one agency may have access to information another agency needs. And so we do get together and work together and, see whether or not there's enough merit to pursue the case, or if on the federal side, they want to settle or they want to dismiss the case. Sometimes that will affect the state unless the state has more strict laws, and so they could pursue it. And sometimes on the federal side, they're not willing to share all information with the state. So it can be difficult state to state as well, depending on, which state is involved. But we do get together and collaborate, and it's just bringing resources together for the common goal.
From my perspective, it's the back end of the litigation or consent decree to make sure that you have OIGs satisfied. You're probably working with the DOJ, well, but then the OIG and then CMS, whoever might want money. Right?
Yeah.
And then the state, you got to make sure everybody knows that there's a settlement that should know. Hiding it won't work because eventually, so sometimes there has to be separate, or if everybody's not included in the resolution of the matter, they need to soon to be made aware of it, and you need to reach out to them before you're satisfied that you're not going to have any more accountability elsewhere, and see, if that makes any sense,
yeah.
especially in False Claims Act cases.
Yep. Okay. Looking ahead, what enforcement trends do you think companies should be focused on? Vivian, you can start.
Vivian, oh, yes, okay. I would just say, looking ahead, the enforcement trends are really the states getting more involved in the action. That's really going to impact the company as far as the damages and racking up the alleged amount that was illegally collected. And so I think to stay on top of that, it just boils down to your compliance program, not ignoring customer complaints, taking those seriously, because in discovery, the emails, the reports of products not working, all of that information will be released. And the way the company reacted to that is what's going to determine some of the damages. So staying on top of compliance, taking complaints seriously, addressing employees that aren't happy, that's major, because that's where these cases stem from.
Absolutely. A lot of whistleblower cases. And we'll talk about that in the compliance session as well. But David?
I would just reiterate faster use of enhanced enforcement is. So I did a recall, and over the holidays, we sent out the press release and the letter. And the next day I got a notice that it wasn't a successful recall. seemed pretty fast.
Right.
Especially with the clientele we were dealing with and who was receiving the letters and the time of year. And I was just like, well, that seems, because they went out the next day to interview store owners to see if they received the communication.
Okay.
Finally, we went door to door. Sorry to do a war story, but, and of course they never would want that before, because then they assume you were diluting the original communication, right?
Sure.
So I think there's just a quicker trigger now that you should be aware of.
Okay, that's helpful. Do we have any questions in the audience in person or? Yeah. Oh, wait, we'll grab a mic for you.
So this is a question about discoverable information with respect to meetings. So let's say your company gets a notice from the FDA, it may be about a recall or something, and everybody gathers together on a video, and somebody's real smart and wants to use one of these transcribing software programs. And the next thing you know, you have a verbatim minutes of your meeting, and somebody during the meeting said something they might not want to have publicized. So the discoverability of these meetings are video meetings where there's automated transcriptions. I'd like to have you comment about that.
I can certainly comment about that. I had a case at the AG's office where one of our smoking gun pieces of evidence was of one of the sales team recording a meeting. And in the meeting, the company was training the sales team on how to twist the words and essentially exaggerate what the product could do, and said, make sure you do not leave any of these handouts at the hospitals or clinic. We don't want any evidence. And all of this was recorded, and it was subsequently produced in discovery. And it was something that I used in a deposition, and it's not privileged unless it's privileged information, meaning it's protected because someone is talking to their attorney or husband and wife. It didn't meet any of the exceptions. So it was 100% admissible, and it was very damaging for the company. So you really do, I mean, you don't know if even right now someone's recording, right, but you do want to be careful. Maybe make a note before a meeting and say, hey, please no recording. And, you know, just take the proper precautions. First of all, don't do anything illegal. But also, you know, you just want to make sure that it's an environment where people are comfortable asking questions, and so you can help your company be successful.
Those note-taking AI things are all over the place. I don't advise using them, especially with the lawyer on the phone. I mean, yeah, you'd ultimately have to be forced with trying to argue that they're privileged. And if there's not a lawyer or if there's not a privilege that would apply, it would be discoverable. So I just not a huge fan of those note taker capabilities that pop up in the meetings.
Yeah, and then running the recording through, AI is maybe a little better.
Yeah.
But it's still
Right.
a quote third party.
Yeah.
Hey everybody. Is this on? Yeah. Okay. My name is Daria Lucas. I'm with the group's regulatory. I'm with the firm's regulatory group. And I see this all the time in larger organizations or organizations that have multiple functions. And I've sort of just made it a regular practice to, because a lot of these functions, they don't know that, you know, this is discoverable information. And so I make it a regular habit to, you know, tell them, please turn off that transcription. I'm regulatory counsel. This is, you know, a privileged conversation. If we want to keep it privileged, that should be turned off. So.
Yeah.
Very.
Oh, we have a question over there. Mike?
Hi there. In regards to escalation, I have firsthand a company that was requested by FDA read-only access to their EQMS. Ultimately, the company granted it. I was at the FDA a long time ago. That was not something that we were requesting access to. And I'm just wondering on the legal basis of that and where's the refusal line drawn?
So they requested a full like access to the software platform with, okay. I mean, I haven't had that come up. I don't know if anybody else has, where you'd actually like hand over access to a portal or a software. I mean, handing over policies upon request is one thing, like paper. Yeah, I don't know. Does anyone have thoughts on that?
Yeah, I think you have a right to refuse that request or negotiate parameters.
Yeah, like a scope of what they're looking for.
Right, what do you want to find out? Maybe we could just provide it to you in a subset. Yeah, so.
Yeah, usually it's just paper document requests.
Go ahead, Ann.
Yeah, Ann might have.
And one thing you could point out is if it's a validated, is this on? If it's a validated system, providing them access isn't what you do with a validated software system. So that's one thing you could try, is that actually it wouldn't be appropriate for me to give you access. Yeah, so they're doing this more. I think negotiating is your best first step. And then you may have to. The other thing is privacy. If they're looking at anything that has patient data in it, that's a different set of requirements that then you have to get over that hurdle. So there might be things that you can just point out as issues. But
We have 3 minutes. Any other questions? Any online? No? Mark? We have 3 minutes left. I think that's for the.
Sorry for the gonna make a quick point that with these AI trackers online, I'm like Daria, I hate those things. Calls, and a lot of times they're just automated, so they keep coming on. But I would be careful also if you are using AI to get legal advice. It's not an attorney. Your conversation isn't privileged. If you're putting it in Gemini or some other, whatever, there's a lot of them now, Claude, et cetera, OpenAI, ChatGPT. There's a court case on this. You can look it up, but there's a lot of issues with attorney-client privilege and confidentiality with those using chat and whatnot for legal advice. So I know Jake and I were just dealing with this the other day. There was this person emailing us helping our client, and I'm like, I think that's a robot talking to us. And Jake's like, yeah, it turns out it is. So we have to go back to our client and be like, this thing that you are calling Susie general counsel is a robot. That's not, you don't have ACP with that thing. So, but yeah, I just wanted to add that.
Yeah, and it's discoverable, your whole conversation with ChatGPT, so, or any of the things. So just something to keep in mind.
Isn't the AI program capturing also it's not just giving you a summary of your conversation, but it's actually putting it into using it to build its own prior.
Yeah.
So it's just a sophisticated listening post. Yeah.
All right.
One more question, I think.
Yeah, one more question. Okay, I was going to say, yeah, we have time. Got a minute.
I just had a question in the same vein regarding, so what I've been coming across lately is with regards to smart communications and sort of write it right. So you want to be able to instruct the sales team, the business generally, that they should think about what they're putting in writing. They should think about how they talk about things. But you don't want to insinuate that it's okay for them to have the underlying intention, but they just have to, phrase it differently. So we've been thinking about how we communicate that in terms of, do they, you want to think it right and write it right? But I'm just wondering what your perspective is on how far you can go with regards to advising the business on smart communications, how they talk about things, how they write about things.
The write it right piece is always a part of my compliance training. I mean, really, you have to get them to understand the rules and why it matters before they can understand how to write and how not to write. So I think it comes down to just training and sharing kind of the reason why in a way that makes sense to whatever audience you're, whether it's sales reps or, you know, clinical or R&D or executive level, getting to understand and appreciate like how it impacts them and the company and our customers. That's kind of the prerequisite to the right at right piece, but they both have to go hand in hand. I don't know if you guys have any thoughts.
Yeah. So I was privileged to be opposite Robbins for the first 20 years. Robbins Kaplan, the law firm, when Mike Cerisi was there, and marketing documents is what he wanted first all the time. I mean, that's the key that unlocks liability. And not scientific liability, not the odds exactly of whether a device or a medicine will cause harm, not that, but about the company conduct. And it's because he was great at distilling a case into what do you know, when did you know it, and what did you do about it? And that the marketing documents. So if you can somehow, without just sounding like a complete, you know, fear monger,
Right. Communicate
that it's a portal. Even doing it really well can be a portal to problems. Might help. I don't know.
Okay, good. I think we're at time. So thank you, David and Vivian. Thanks for everybody. The good questions.